So in this video, we are going to discuss estate planning. So most of our content mainly deals with retirement planning. But Shaun, why do you think that estate planning, including topics of wills, power of attorney, and healthcare directives, is such an important part of retirement planning as a whole?
Well, because if you don't pay attention to this, all the hard work you put into your retirement plan could blow up on you. And I'm being a little bit dramatic, but it can be true. So, most of our clients, most of the people we talk to have sacrificed, they've worked hard to build up financial assets and pensions for their retirement. And they're very intentional around their portfolio strategies and dealing with the accumulation risk and sequence of return risk and inflation pressures and trying to get clear on how much they can spend. But if you don't pay attention to estate planning, and the retirement plan might be the initial focus, but estate planning, if not looked at and updated on a regular basis, creates a whole bunch of potential issues. And those issues could lead to too much tax being paid, excessive erosion from the estate because of administration costs, probate costs, and you could see family strife, unnecessarily so, because there haven't been important conversations that have taken place between family members. So, although the focus absolutely is retirement income plan, which can shed some important light on estate planning, you do want to pay attention to this area because it could cost you dearly if you don't have effective planning in place.
Yeah, it's really good. And so to prepare for this video, I did a little bit of research around statistics on how many people have wills and power of attorneys. And so pulling data from the National Institute of Aging and RBC Royal Trust, I'm just going to read out some statistics I think will really set the scene for why this is such a relevant conversation. So they found that 30% of Canadians have an estate plan and 48% have a will. While 74% of Canadians aged 55 and older have a will, only 34 of age 35 to 54 years old have a will, and 30% age 18 to 34. When it comes to power of attorneys, 35% of Canadians have appointed one. Among 55 years old and older, the figure is 53%, but it drops to 28% for those 35 to 54 and 21% for 18 to 34 years old. So this data was collected using a sample size of about 2,000, which isn't necessarily as big as you want it. And it's from 2022, but I think it's probably quite similar now in 2025. And the obvious question that arises from that is, why do you think so many people, especially in that 35 to 54 age group, haven't put in the time to get a power of attorney or get a will set up?
Yeah, there's probably a few simple reasons for it. One reason is, I think at a subconscious level, we just don't want to deal with the issue, right? So that keeps people from planning. So that's one reason, and that's a reason that everyone has to sort of fight through. The other reason is a lot of people just think that their situation doesn't warrant estate planning, or they think things will magically flow to the people that are supposed to get them when they die. And so there's a lack of intentionality around, okay, what actually happens if I die? What happens with my spouse, for my kids? If I don't have a partner, what are the implications there? So I think it's just an afterthought. People just don't want to deal with it. Maybe they think it's complicated. But I think subconsciously there's a big issue there. And even people that have put wills in place or put powers of attorney in place, one of the things we find often is they don't review the documents. They don't keep them up to date. So they put a lot of time and effort into drafting those documents with their lawyer. And then over the passage of time, there's been changes. And those changes could have a really big impact on the estate plan. So I think all those factors sort of play into why people either don't do it or don't have up-to-date plans.
So the way we're going to format this is I'm going to act as pretty much the viewer. And I'm going to throw some questions at Shaun, and he's going to kind of get into the details of them. So how can one ensure that their assets are distributed as intended?
The first principle is make sure you're taking a look at things and you start there, right? You intentionally look at your intentions around estate planning. So there's two main ways that you can get financial assets or real estate assets or estate value to, family members, partner. It's through the operation of law and through the estate. Now, so the estate typically is through your will, and then your will give direction in terms of how assets are to be distributed. The operation of law is the whole area of beneficiary designations, whether that's RIF accounts or TFSAs, pension plans, life insurance. And one of the benefits of using beneficiary designations is those assets pass directly free of the estate and right to the intended beneficiary. That's not always the right way to do it, but that's one way of making sure that assets get to beneficiaries. The other is through the will. And so you have to pay attention to your will. You have to pay attention to the designations you make on investment contracts. You have to pay attention to how you've registered accounts. And your decisions in each of those areas will determine how those assets will flow to various family members or even to charities or other organizations. Um, that is something you should be updating on a regular basis. And I'll give you a great example. There's often situations where people will draft an estate plan. They'll talk to their lawyer, and then a number of years go by, and they walk into their financial institution and they look at their account agreement for their RIF account or RSP account, and the advisor there, good intention, said, "I notice that you do not have a listed beneficiary on your RIF account. We should change that. You should list the kids as an example, have that money go directly to them. Let's say it's a widow or widower. Yeah, that might be a good idea. Yeah, you'll save on probate fees. It's convenient." And you end up changing the account agreement to list your kids as the beneficiaries. Now what's happened is your will says something different. The reason you didn't list your kids as beneficiaries is that you wanted that money going into the estate, taxes to be dealt with. You had a few charities as well. Once the executors dealt with those things, then releasing assets to the kids is what you want to see happen to your grandchildren. Now, with a stroke of a pen, years later, you've done something on your account agreement that now contradicts your will, and that account agreement now will supersede what you say in your will. And that's why it's so important that you review this documentation, your will, your power of attorney, your account agreements, pension plans. Do you have the right beneficiary designations? Do you have the right registrations on the accounts? And things like marriages, divorce, separations, new members to the family. The rough rule of thumb is make sure you review the documents no less than every 5 years, or as there have been changes to your personal or financial circumstances. And that's a good rule of thumb to go by.
So the next question is, most families or many families reduce their assets that will go to the state, obviously to avoid probate costs and to simplify the state administration. Is this always the best choice for them?
It can be, yeah. So it's a good question. They want to reduce what's going to the estate so they don't have probate costs and have money sort of tied up in the estate, and there's additional costs through that process. So I think in general, the basic principle probably should be, if you have a partner, right, then through the operation of law, like joint registration and beneficiary designations, you want to make sure that those assets just roll over to your surviving partner and they don't have to go through the estate. And it's simple administratively, and it's not complicated, and it is very quick. Right? Where you start getting into complications is an last die scenario, particularly for couples. So, you got the husband, you got the wife, husband passes away through the operation of law and beneficiary designations, and using those contracts, you get the money to the surviving spouse. Now that surviving spouse has passed away. And what you see happen a lot is families go, let's try to reduce probate costs. So through, joint registrations and beneficiary designations, that's what they've done. That's not appropriate for all families. And the reason for that is that, and there's a few things, right? So number one, there could be some tax implications attached to that. So one of the things you find with estate settlement is there are tax costs. Sometimes assets are released without holding back tax. And then the executor is looking to settle the estate, and assets have been released to beneficiaries already. And now the executor has to file and pay taxes, and the money that they would use to pay those taxes is no longer there. So now they're going back to beneficiaries and trying to extract money from them to deal with the taxes. So that creates obviously some complications. So sometimes the recommendation is to, batten down the hatch, have everything go to the estate, get the tax calculation done, the clearance certificate from CRA, and you don't release the assets until that process is done and it's clean and it's well organized. The other reason that you would want money going through the estate and not being so focused on reducing probate is, again, if you have trust set up, the money has to go to your estate. So many people have trust set up, and examples would be testamentary trust for dependents, but there could be even trust set up to protect assets. So example is, many people will set up testamentary trusts for the next generation if they have concerns about how solid a marriage is, whether their kids are in business and they're concerned about creditor protection. So rather than putting the money directly in their hands. On death, the money goes into a trust and it's protected and segregated for their benefit if they have some of those concerns. The other reason is charitable giving. So again, to get the donations, and there's an unlimited amount that you can gift through your estate, and it's a very significant tax planning opportunity. But you can't take advantage of it unless the money is going into the estate. There's a direction by the will, and then you can take advantage of that. So if you're bypassing money from the estate through beneficiary designations and joint registration, now you're getting in the way of that intention. And then if there's family strife, the general recommendation is don't start passing money out on the last to die. Put it in the estate. The executor sort of is the arbitrator of what happens. Again, they just make sure all the details are looked after. And once that's done, then they start releasing money to the beneficiaries. So every family is different. And, some families, they really communicate well. There's good relationships. But I can tell you, the fastest growing area of litigation in this country is in the area of powers of attorney, executors being litigated against by family members. Those same people launching, family members launching litigation against powers of attorney and executors because they don't think they've done their jobs properly. So it's a big deal. Don't be so focused on reducing probate costs that you don't see the forest for the trees. I guess that's the basic message.
That's a good point. Power of attorney. So in thinking about who we're placing as power of attorney and all that, so what are the roles of a power of attorney in estate planning?
So it's always surprising to me, although I shouldn't be surprised. A lot of times people will use power of attorney and executor interchangeably, but obviously they're very different roles. So a power of attorney is someone you appoint, you're still living, but you're incapacitated or you can't make decisions on your own and you need your power of attorney to step in, whether it's because cognitive issues, health issues, that kind of thing. And there can be powers of attorney both for health as well as property. But the basic idea is to have this document in place so that if you can't act, you've empowered somebody to do that for you. It's not an expensive document. It's a fairly simple document. And I think that, who plays that role? They just need common sense. There needs to be close proximity, right? So you ideally want someone who's living in the same city and they can take the time out of their schedules to help you, particularly if you're older, in terms of care needs and that kind of thing. So common sense, proximity, kind of know your situation. They don't have to be a tax expert or an investment expert. I think they have to have the common sense to seek out advice. And the biggest thing about a power of attorney role is that there are fairly stringent requirements the power of attorney needs to follow in terms of how they handle the assets of the individual, the accounting aspects, being accountable in terms of where money has been spent, how it's been used. So you want to make sure that if you say, yes, I'll help you, I'll be your power of attorney, particularly if it's not a family member or it is, maybe even a child, you need to understand what the responsibilities are. That's where people get in trouble. People are good-hearted, right? They put their hands up to help out, but they don't realize, what that role entails. And if they don't fulfill that role properly, there may be other eyes watching and they may seize upon an opportunity to litigate because they didn't think you did a very good job. And that's not a situation you want to get into. We know that the law firm we deal with, one of the things the lawyer does is anytime someone's appointed a power of attorney, they give them a little bit of a power of attorney school and talk about what the responsibilities are.
Yeah, it's definitely a lot more of a commitment than I think most people would think. So in every client meeting,
and actually just one other comment on that, Josh. I mean, often I'll talk to people and they go, well, just me and my partner, and why do we need a power of attorney? And I go, well, not everything you have in your situation is jointly registered. Obviously, if there's a joint asset, you can deal with it. But if you've got a pension plan or you've got a TFSA or you've got an RSP account and your partner loses their cognitive ability and they can't make decisions, if you don't have a power of attorney, you're out of luck. You're going to have to go through the process of committeeship, get the courts to appoint you to represent that person or act for them. And that is a time-consuming, expensive process. So spend a few $100s, a couple $100, get the power of attorney in place. If you don't have one right now, it's just going to save you all kinds of trouble down the road. So it's an important document.
Yeah, for sure. So in every client meeting, we review whether the person has a TCP, or also known as a trusted contact person designation in place. So Firstly, what is a TCP and why is it so important?
Yeah, the TCP or the trusted contact person is a really valuable document. In our business, of course, we do both retirement planning engagement, but we also do asset management for our clients. And, one of the issues historically is this sort of gray zone when you're working with a client and you've been working with them for a number of years and you start noticing things. And you're realizing there might be a little bit of slippage in terms of how they're following the bouncing ball. But that's kind of an awkward conversation, right? That's not an easy conversation to have with someone. So the trusted contact person form is basically a document that we make sure is in place for sure for every single person in our practice, widow, widower. We do encourage couples as well to have it, but certainly anyone that's on their own. So that if I was ever in a meeting and I get the client to sign off on the document and the TCP is someone that I can reach out to if I have any concerns. Client goes, you know what, Shaun, if you ever have any concerns, contact Sally. She knows my situation. Totally get it. And those concerns could be cognitive, could be health issues. It could be we're trying to get a hold of a client and we're not having any luck, so we can reach out to someone. For couples, you could be traveling and there's maybe some time sensitive issues, financial issues. Again, we can reach out to the trusted contact person to get information. Typically, a trusted contact person, we can't divulge any financial information. The only thing they know is that the client has a relationship with us. But I've had situations in the last couple of years where I've had to contact a trusted contact person because of some issues that come up for clients, either cognitive issues or even concerns about fraud issues. And so it's a very useful document. And certainly if you're on your own, you want to make sure your financial institution or your advisor has it in place to be an advocate for you, to look out for you.
Yeah. All right. Question. I believe this is 6 or 7. How does a up-to-date retirement plan provide guidance for your estate planning?
The retirement plan is a wonderful document to give you some visibility as to what the future is going to look like potentially. So as you decide on what your deaccumulation plan is or your spending plan, what you also find out through the retirement income plan is how your net worth will change, and not just your net worth, but your tax position. Now, where that gets really interesting is we can start having some fruitful conversations about, are there things that we can do today to reduce the terminal tax cost, the down the road tax cost on the estate, right? That's a great conversation to have. Let's be intentional. For some clients, we can combine their aspirations for making a difference, legacy, and charity by saying, hey, we can make a big impact here. The retirement income plan confirms that you've got more capital than you need for your own long-term financial security. And obviously, we want to be really cautious on the assumptions we use in the model, but it's very often we have clients in that situation. Well, now we can have a conversation about maybe it makes sense for you to have a charitable giving strategy. Sometimes as a donor advised fund or gifting, where you start gifting assets intentionally, either to charities for tax purposes, huge benefits there, or even to family members. So it's very common for me to run a retirement income plan. You've seen this, Josh, in the modeling where we go, you know what, you've got more capital than you need. You have the ability to gift to the next generation now while you're alive. You can see impacts on the grandchildren, and this is not going to impact your own income security. So the retirement income plan is just foundational to those kind of discussions. It's really, really helpful.
Yeah. So you mentioned earlier that people often use the words executor and power of attorney a little bit interchangeably.
Yeah.
So what are some factors that people should be considering when selecting their executor?
So one of the big differences with an executor compared to a power of attorney is that sometimes the power of attorney role can be an extended long-term role. So you think of a loved one who is not in great health, but they could be in that situation for years sometimes. So not everyone can fulfill that role. And as well, they may have to have flexibility in their calendar to leave work. Maybe they're not working, so you have even more flexibility to go to doctor's appointments and that kind of thing. The executor is different. It's a more of a defined engagement. It may not be done in 6 months, but usually over a course of 1 to 2 years, the executor responsibilities are done. You don't have to necessarily live in the local area to get the work done. I think there is an important requirement to have good common sense. I think having some financial knowledge is helpful, but it's not necessary. I think common sense, diligence, following through are all really important factors, and the willingness to ask questions. So when you don't know something, talk to the financial advisor, talk to the lawyer, talk to an accountant to get clarity on what needs to be done. So I think that's really the most important thing: common sense, ask questions, and if you've got those things working for you, then your appointment should work out very well for you.
Yeah. So this next one you also touched on a little bit earlier, but why is it essential to update your wills and your power of attorneys regularly?
I think it's just good financial hygiene. It's always a good idea to take a look at these documents in the context of major life changes. So those could be retirement. That's a major one. So retirement is always a great time to kind of dust off those documents and update them if needed. Separation, divorce, not a good thing if you go through a separation or divorce. You're now in a new relationship, and then years later, you forget that the old will was never changed and your ex is still a primary beneficiary in your estate. So you want to make sure that if there's changes to your personal circumstances, that you're updating those documents. And over time, looking at the operation of law, so joint registration or beneficiary designations, compared to having assets going through the estate, that's a good question to ask every once in a while. What is the best way of doing that for you? Certainly, if you have a partner, most of your focus is going to be transferring assets through the operation of law, beneficiaries, joint registration. But you want to really wrestle with how are you going to distribute assets once there's a last to die scenario. And that's a little more complex planning. And your lawyer and your financial planner can play a really great role in helping you to work through those decisions.
Almost done here, but what is a common misconception that people have about estate planning that you see very often?
I already mentioned it. I think the number one reason that people don't get onto this is they just don't think their situation warrants planning. I don't have enough
Yeah.
money. I don't have complexity, and that's not the prerequisite for estate planning. The prerequisite for estate planning is you love someone, and you're concerned that if something happens to you, you make that transition as easy as possible for your loved one. That's why you do this. And then secondarily, you might have some legacy or estate planning considerations that are important to look after. So that's probably one of the main reasons. They just don't think it warrants the planning. And very few people are in situations where an estate plan is not warranted. It really is an important part of overall planning.
Yeah. Yeah. Lastly, and probably most importantly, if someone wants to get started with this, they want to kind of plan out their estate and bring everything together. How can they get started with it?
Well, the first thing I would say is number one, view this as a team or a collaborative effort. Like I think the best estate plans are done in collaboration with your financial planner and with your lawyer, and sometimes your accountant will play an important role, particularly if you're a business owner, as an example. Um, Part two of that is do some planning and forecasting. So a lot of the work that we do for our clients, again, like I said, give people visibility to the future. And that begins to give us some ideas about potential planning opportunities that we can begin working into the client situation. The use of trusts. Do we have assets going through the estate? Yes, they might be subject to probate, but maybe having money going through trusts makes sense for the client. Do we incorporate charitable giving into the estate planning? What are the benefits there in terms of reducing taxes on the estate? So the planning confirms whether that's even an issue. Obviously, if you're going to spend every dollar you've made the day before you die, not an issue, right? You don't have to engage in a lot of estate planning. But if you've got growing capital assets, business assets, estate planning is really, really critical. So think of it as a team effort. Start the conversation often with your financial planner because they're seeing the overall picture. And then you can tactically bring in your lawyer and your accountant as part of the team to round out the plan.
Yeah, I think the way you unpacked it today has been really helpful. There's definitely a lot more nuance to estate planning and really retirement planning in general, but specifically estate planning that I think most people expect. And so, Shaun, if someone's watching this and they're going, "Hey, how can I take control of my planning, retirement, and estate? How can I do that?"
Well, we're very I think the retirement income plan is a foundational document because it sheds a lot of light on these topics. So if you don't have a retirement income plan, if you're not sure whether your estate planning is synced with your financial planning properly, then make sure you go to the show notes. There's a link back to our website. You can find out how you can get a complimentary retirement gap analysis discussion. There's a link to our offices where you can set up a complimentary call. And yeah, make sure you subscribe. We're posting content like this all the time. So if you subscribe, you won't miss the future posts that we do.
Awesome. All right. Well, thank you for tuning in if you made it this far in the video, and we will catch you in the next video we produce. Take care.